Selwyn Moses.
Good afternoon, Mr. Blaze.
Good afternoon. Well, good morning, actually.
Indeed, good morning for you. Thank you very much. Now, hopefully you can hear me clearly.
I am hearing you, my lord.
Thank you. Well, we can hear you very clearly too. We've read the papers, we have read your written case, and so it's now for you to open your appeal and make your submissions.
Thank you, my lord. My lord, based on the ruling from the Court of Appeal, we would want to start, I think, with the basis upon which the Court of Appeal would have introduced itself from the standpoint of being able to make a decision relative to this matter, i.e., indicating that the judge in the High Court had fell into error.
I'm sorry.
Now,
could I just stop you for one moment? There's a certain amount of delay on the line, so it would certainly help me if you could make sure you're speaking into the microphone and not too quickly, because in that way we can pick up what you're saying, even though we're receiving it a short while after you have said it.
Oh, I see. Yes, my lord, I will try to adhere to that. So, my lord, you would have had an opportunity to look at my submissions, which would be at page 25 of the key bundle.
Thank you.
And I would have given a summary of what the High Court, what the actual matter was. What I also want to add to that as well is, and at the High Court level, just prior to the matter being heard, the court had inquired of the ancillary claimant as to if they intend to seek to set aside the deed, which is the 1984 deed, which is the subject matter of these proceedings for the most part, then all of the parties that may be affected by that would have to be made parties to the proceedings. At that time, the ancillary claimant indicated that they were not pursuing that, in that they would not pursue conveyances that had already occurred. The only thing that they were interested in would have been the lands that were still in the name of Selwyn Moses, which would have been the ancillary defendant, at the point in time of the commencement of the proceedings. And their position was the land that he still holds was parcel number 17 and a parcel called parcel A. Based on adopting that position, the court ordered a title search. And the results of that title search is at page 606 of the main document. Initially, that title search wasn't brought before the Court of Appeal, but when the court was made aware of it, they instructed the present respondent to ensure that that document is before the Court of Appeal.
Page 646, I've got paragraph...
606.
Oh, 606, thank you.
Yes. All right, and so you would see it would have been a report that would have been commissioned by the ancillary claimant. And the report would have revealed that at the time of the commencement of the High Court proceeding by the ancillary claimant, the ancillary defendant had in fact divested himself.
Yes. Frozen. Ah. I'm sorry, we seem to have lost the link at the moment. The image is frozen.
Did you want to adjourn until we get them back?
Is there somebody following this online? Mr. Blaze, I suspect you can't hear me, but certainly the link is still frozen so far as we can tell, and so we are going to adjourn now until our technical people manage to restore the link so that we can see and hear you once again. Thank you.
One second, let's see if they manage to.
It's going to take them a while, I think.
You think so?
Oh.
Please arrange for someone to speak to me directly. What's going on?
Oh, baby.
Mr. Blaze, so far as I can tell, we lost contact with you about 2 or 3 minutes ago. You'd just taken us to page 606 of the bundle, and the report on title, which begins at page 609.
Correct.
We had that reference, and at that point, we lost you. But I understand now that the link has been restored. We can see you, and we can hear you. Can you hear me clearly?
I can hear you, sir.
Very
Can't
well.
see you, but I can hear you.
You can't see me.
No.
Would you like a moment or two longer to see if we can restore the video link too?
That is fine.
You're content that we proceed?
If you wish for me to proceed, my lord, I will proceed.
Well, would you like a moment or two longer so that you can?
Okay, I'm seeing you now, my lord.
You can see us now.
Room now.
Very good. Right. Well, we'll resume. Please work on the assumption that we lost contact with you just after you had referred us to the report on title at page 609 of the electronic file.
Yes, sir.
Thank you.
So 609, and the results of that report established that at the time of the commencement of the action against the ancillary defendant, he had already divested himself of all of the lands that are the subject matter of these proceedings.
Yes.
All right, so what I also want to refer the court as well is in support of what I indicated about the position adopted by the ancillary claimant. I would want to point the court to page 251 of the main document. And that page 251 of the main document is the last page of the submissions put forward by the ancillary claimant at the High Court after the hearing of the matter in the High Court. And what the court would see that the reliefs, based on the discussions that the ancillary claimant will have had with the court, two things happened. One, they abandoned their pursuit of the claim of fraud. And two, they indicated that they were not seeking to challenge the title to various lands that were sold. And if you look at 251, you would see the reliefs that they were asking for, which are different to the reliefs that they would have had in their amended statement of case. Those reliefs would have flowed from what the parties, the position the ancillary claimant would have adopted at the trial with respect to what they were interested in. So they were still pursuing claim with respect to the trust, even though the first paragraph of the release says the setting aside of the deed, the last paragraph indicates that they were not challenging the conveyances that were already effected with respect to the other buyers. Inherent in that, our submission is an acceptance that the 1984 deed had in fact conveyed an interest to the ancillary defendant, because it's only on that basis could they then pursue the claim of the trust or pursue the claim of reconveyance of any land into their name. Now, the position of the Court of Appeal also reflected that particular approach. So if we look at page 68 of the key bundle, at lines 9 to 15, the Court of Appeal, in questioning exactly what they were seeking to challenge, said...
Just one moment. I want to be clear where you are. Which document are you looking at? Page 68 of the...
The key bundle, which deals with the notes of evidence from the Court of Appeal.
I think it's 628.
Is it 628?
No. Okay, they may have been... Okay, you're looking at...
Can you give us the electronic
page
file?
11, page 11 of the notes.
Can you give us the electronic file reference?
What's the electronic file reference? notes of evidence.
11 of the transcript.
566.
566.
Yes, it's in the notes of evidence.
Yeah.
Right. Certainly, for my benefit, it would be of great assistance if you could always give us the electronic file reference together with any other reference you might like to give us. Because
Yes, ma'am.
so page 566.
Yeah, 566. Yes. Yes. And at line 9 to 16, you would see the Court of Appeal questioning the attorney for the ancillary claimant. Said, why are you dealing with this? You are not seeking to challenge the dispositions, as I understand from your appeal and from Mr. Blaze. You are not seeking to challenge the disposition made to bona fide purchaser for value without notice. Isn't that what that deals with? And he says yes. So I say that by means of confirming that even at the Court of Appeal, it was clear that the ancillary claimant, which is the respondent in this matter, was not challenging the conveyance to persons that they identified bona fide purchaser for value. Now, the only way that that can exist is if the 1984 deed validly conveyed the property to the ancillary defendant. Now, this now takes us to the decision or the order of the court below, which is at page 108. It's 108 of the key bundle, and what is it in the electronic bundle? So the actual will be 108, and I will get the electronic bundle for you, Malone. Frank Superstar, the High Court. The order itself. No, the key bundle. Sorry. And the key bundle is 108. I don't know if my lord has in fact found the order. No.
Page 148, I've got the deed of conveyance. 108.
So you're looking at that. That's the full bundle, but it's 108 of the key bundle that you have the paper copy of.
It is actually the key.
277, I think.
Yes, right. It's in the key documents bundle at 108.
Thank you. We've got it.
277, yeah.
Yes, we've got the order now.
Right. So that was the order from the High Court, in which the order dealt with two things. One, it dealt with the declaration that the lands were properly vested into the name of the ancillary defendant. And then two, it dealt with the issue of cost. That is what the order of the High Court dealt with. That's what the order of the High Court contained. Now, the order of the Court of Appeal, which would be, if we're looking at the key bundle at page 35, and 554 in the general bundle, but 35 in the key bundle. My lords, being able to
Yes.
find the...
Thank you.
Yes. At paragraph 2, it says the order of the judge is that the claim and the counterclaim are set aside.
Yes.
But the order just merely indicated just merely indicated a fact which was not before the Court of Appeal and which was accepted at the High Court level, which is that the 1984 deed properly vested the lands into the name of the ancillary defendant, which is the appellant in these proceedings. So our first point, my lord, deals with the issue of the judges, the basis upon which the judges of the Court of Appeal disturbed the judge's findings of fact as it relates to the 1984 deed. Now, if we look from the standpoint of the key document at page 126, are the final three pages of the reason for the decision of the High Court. And that decision, my lord, is contained, and the points to which I would want to refer, my lords, to would be paragraphs 33.
I'm sorry, you're just going to have to give me the electronic file reference page.
It's 295.
38.
295.
Now, I'm saying that from the standpoint of then getting into the appeal court's reason, which the court can find at page 46 of the key bundle. And 546 of the main bundle, but 46 of the key bundle. And I would want, my lords, I'm referencing paragraphs 24 to 31. And that was the basis upon which the Court of Appeal indicated that they were able to set aside the High Court's finding of fact and then thereafter proceed to substitute their own. So our submissions, my lord, is that they erred in the finding, in setting aside the High Court's finding of fact. And the authorities of which we are depending on would be at page 25 of the key bundle. The main authority being Beacon Insurance Company Limited versus Mirage Bookstore. And in that case, my lord, they said the Beacon case provides guidance on the basis upon which an appellate court may reverse findings of fact made by a judge at first instance. The board restated well-known principles and drew from several well-known decisions. The board noted that it is only in a rare case that an appellate court will interfere with a trial judge's finding of primary fact. Such a case would include one in which there is no evidence to support the findings, B, a decision which is based on a misunderstanding of the evidence, and C, a decision which no reasonable judge could have reached. And we turn to the next page, which is on page 26, my lords. Also refer the court to the words of Lord Hoffman in Biogen Inc. versus Medeva, which was also cited in Beacon. in which he says, the need for appellate caution in reversing the trial judge evaluation of the fact is based upon much more solid grounds than professional courtesy. It is because specific findings of fact, even by the most meticulous judge, are inherently an incomplete statement of the impression which was made upon him by the primary evidence. His expressed findings are always surrounded by a penumbra of impressions as to emphasis, relative weight, minor qualification, and nuance, of which time and language do not permit exact expression, but which may play an important role in the judge's overall evaluation. Additionally, I refer my court to Lesuskov, I hope I have that pronunciation correct, versus Skystream Corporation, the extract of which I have at page 27. 698 of the major bundle. Now, the quotation from that, they say, in the board's view, this was a classic case, and this is what is highlighted in italics, in which there was a good deal to be said on each side regarding the primary facts and what inferences should be drawn from the primary facts and the circumstances in which the parties were acting. It is the function of a trial judge in such a case to weigh carefully the points made by each side and come to a definite conclusion. This is what the court did. When I go down to the last paragraph, it says, the Court of Appeal considered that the judge committed certain fundamental errors in evaluating the facts, which meant that his assessment of the evidence and the conclusion to be drawn in light of it could not stand. With all respect to the Court of Appeal, the board cannot agree that the judge made any fundamental errors. And certainly in this case, my lords, it is our submission that the judge did not make any fundamental errors with respect to the determination concerning the validity of the 1984 deed. So I would go back, my lord, to the Court of Appeal at page 46, 48, paragraph 24 to 31. The court says at 24, the second paragraph, my lord, the judge was of the opinion that to find in the appellant's favor, he was required to have direct evidence of her state of mind at the time she executed the disputed deed. In this regard, the judge misdirected himself and thereby fell into error. My lord, I would want to refer to page 126, which is the actual reason that the court gave. And this is page 126 of the core bundle, of the key bundle, of paragraph 33. The court went into an analysis. In the instant case, the ancillary claimant directed the court to what was suggested as being glaring errors in the 1984 deed. So the court, one, did take into consideration the content of the deed, did notice the content. And then at 34, the court went on and said the court is empowered to go behind what is stated in the recital to the deed and can ascertain what the true facts are. In the 1984 deed, it was stated that the ancillary claimant was desirous of conveying the property to the ancillary defendant. However, the ancillary defendant was not the beneficiary of the lands under the will. It is accepted that an executor cannot alter the intentions of the testator. However, although the deceased left the property to the ancillary claimant, she was free to divest herself of the said interest. She was not only beneficiary, but also under the 1984 deed, The ancillary claimant, as the personal representative, was usually empowered to deal with the said lands, and she elected not to assign the property to herself, but instead convey it to the ancillary defendant. The title which recorded the ancillary claimant, the beneficiary of the land under the will, was clearly not accurate, and cannot be disputed that the property fell into the residuary estate. However, the ancillary claimant unilaterally and without coercion elected to deprive herself of the said benefit and interest in the said lands, and she elected to convey the beneficial interest in same to the ancillary defendant. There's no evidence adduced. There was no evidence adduced before the court that could have led the court to conclude that the 84 deed was executed as a result of a mistake of fact, or that the ancillary claimant was a victim of fraud or deception, undue influence, or coercion. Goes on to say the proper process that should have been adopted should have been an assent to the land and then a conveyance. The failure to follow that process did not invalidate the conveyance. There's no evidence that can lead the court to conclude that the material time the ancillary claimant was unaware that she was the actual legatee. Now, all of this, what has been said, also taken into consideration that before the commencement of the trial, the ancillary claimant conceded a particular position with respect to the title by saying they are not, they were given the opportunity. If are you challenging the will, you have to go after everyone. If you're not, then they said, no, we are not doing that. What all that we are doing is that we have brought this action in trust, and what we are doing is therefore pursuing whatever lands are still in the name of the ancillary claimant. So therefore the issue of the title deed itself was not a substantial matter that was an issue. So therefore the judge's findings could not be deemed to someone to be something of a fundamental error, taking into consideration all that he had to take into consideration. The deed, the evidence that was given, the concessions that were made at the trial, everything that was taken into consideration, the judge did in fact do that and then come to a conclusion. Our submission is that at no point in time the judge fell into error, because all the court is saying that he should have taken into consideration, he did. The fact that he came to a different conclusion does not give the Court of Appeal the right to now proceed to say that his findings of fact, which he was in the best position to be able to make, being the judge and being able to have, based on the authorities, a more holistic grasp of all of the facts to be taken into consideration, including the concession made by the claimant before the commencement of the trial.
Mr. Blaze, could I ask you a question, please?
Their submission,
this is Lord Sales speaking. I don't know if you can hear me.
which the
Can
Court
you hear me, Mr.
of
Blaze?
Appeal itself even accepted. They cannot say that the judge fell into error with respect to the matters he took into consideration in making a determination as to the validity of the 1984 deed.
Thank you, Mr. Blaze.
Now,
Lord Sales,
the
Mr.
Court
Blaze,
of Appeal
Mr. Blaze,
introduced
can you hear me?
the cause of action of unjust enrichment
I'm not sure you can.
at the Court of Appeal. That was not a matter
Could you
before the High Court.
get up? Please ask our technician to get up.
All that was before the High Court initially would have been,
Mr. Blaze,
after the concession especially, would have been the issue of a trust, which the court dismissed based on the fact that they were unable to substantiate the existence of a trust. The Court of Appeal themselves also dismissed indicated that they would have failed with respect to the issue of the establishment of a trust. So with respect to what the High Court had to deal with, the judge could not be said to have fallen into error, bearing in mind all of those facts, all of which the court also had an opportunity to look at.
David, I think we're going to have to adjourn.
The High Court judge could not have been said to have fallen into error. And if the Court of Appeal was wrong, and we are submitting the Court of Appeal was wrong, then automatically the result is their order has to be set aside.
Shall we just let him finish?
Because their order was based on the judge falling into error with respect to his finding of fact, or fundamental error with respect to his finding of fact, which then entitled the Court of Appeal to look at the matter anew and then substitute its own decision based on a cause of action that was raised by them for the first time at the Court of Appeal. So our first submission deals with the issue of the Court of Appeal itself falling into error in setting aside the findings of fact by the High Court judge.
Derek, we're going to rise.
And we and
Mr. Blaze.
I am, like I said, we will base that on the submissions that we would have made
We're going to have to rise.
You'll have to see us.
as indicated to the court.
We're going to rise now. Thank you. 2:30.
Now,
He saw that. So
No, we're going to
yeah,
rise.
we'll go out and try and re-establish sound content. That's not a good sign.
So we lost the picture.
hello, my lord.
Mr. Blaze with no picture.
Maybe he switched his camera off. Let's hope that's it.
Now, Mr. Blaze,
Yes, my lord, I'm hearing you. Are you hearing me, my lord?
we can hear you. Just wait one moment, please, because we're waiting for the picture to be restored. Now, thank you. We can see you again. Can you see us?
Yes, my lord, I can see you.
Thank you.
Well,
can
small, but I can see you.
you hear us clearly?
Yes, my lord, I can hear you.
Thank you very much. Now, I'm afraid, due to technical difficulties, we lost contact with you, but we did hear your submissions on the first question, which was the finding by the judge, the Court of Appeal, and the concern about the Court of Appeal interfering with the finding of fact made by the first instance judge. Now,
Yes, my lord.
Lord Sales has got one or two questions for you in relation to the submissions that you have just made.
Yes, my lord.
So, Mr. Blaze, you had referred us to the passages in the judgment of the judge in the High Court, in particular paragraphs 33 through to 35.
Full amount is 33 to 38.
Yes, including, for instance, at paragraph 35, where the judge said there was no evidence adduced before the court that could have led the court to conclude that the 84 deed was executed as a result of a mistake of fact. And I wanted to ask you what you had to say about paragraph 25 in the judgment of Justice of Appeal Jones in the Court of Appeal, which is page 46 of the Key Bundles document, where she focuses on the passages that you took us to and draws the conclusion that these passages in fact show that the judge did not approach the task before him in the proper way because he did not engage in an overall assessment of the evidence to determine whether the 1984 deed had been made by a mistake.
No, but
the very fact that the judge said there was no evidence that could have led the court to that conclusion, in her view, was indicative of an error by the judge that he did not weigh the evidence in the proper manner. And I wanted to ask what you had to say about that.
Yeah, so, my lord, that is why I referred, my lord, back to the findings of the court. The court did take that into consideration. The Court of Appeal would seem to suggest that the court did not take into the consideration at all with respect to the issue of it being an error. But the court did take it into consideration, but reached another conclusion. The court is saying, yes, I see that there is information in the deed that is incorrect, but I do not accept that by itself as being a clear sign that she was unaware of what she was doing at the point in time of the execution of the 1984 deed. So there's a difference between not taking it into consideration at all and taking it in consideration but coming to another conclusion. And we are talking about the judge now who would, unlike the Court of Appeal, that this merely has the information in writing, who would have had the benefit of dealing with the matter, dealing with the witnesses. Again, like I said, the nuances, also would have had the benefit of hearing what the claimants would have made with respect to the concession before the trial itself. So we are saying it could not have fallen into error on that particular issue because it was in fact taken into consideration. Now, the other point they make as well is, well, Lord, you all are hearing me? You all?
Yes, no, we can hear you. Thank you.
Right. Okay, right. Right. The other fact I wanted to make, it has to be a fundamental error relevant to the issue at hand as it pertains to the interest, the 1984 deal conveying an interest to the ancillary defendant.
Yes, but Mr. Blaze, if there had been a failure properly to weigh all the evidence bearing on the issue at hand, would you not accept that that was a fundamental error by the judge?
Well, if there was a failure to weigh, but the court did weigh it, my lord, and the court specifically mentions the information in the deed itself. The court says there may be at 35, at 33, the court made reference to the errors, the ancillary, erroneously described as beneficiary, the W lands and the Milton Moses gave, bequeathed, and divided unto the beneficiary the land described in the schedule to the said deed. So it's not that he did not weigh it. He did in fact weigh that particular aspect of it. It's just he came, based on weighing it, he came to a different conclusion. But it cannot be said that he did not weigh it.
Mr. Blaze, do you think it's a question about the interpretation of the words "there was no evidence adduced"? Because it might be said that what is meant by that is no evidence over and above what is referred to two sentences before, which are the errors in relation to the deed.
You mean that no evidence adduced over and above what is in the deed itself?
Yes.
No, I mean, as from the standpoint of the judge or what the Court of Appeal was saying. I'm trying to be clear what my Lord is asking me.
I'm trying to ask what is meant by the phrase, there was no evidence adduced before the court when the judge has just referred to errors on the face of the
Correct.
document.
Right. So that's what the High Court would have been referring to. There's no evidence adduced over and above what was in the deed. That is what the court was alluding to. And they needed that additional evidence in order for him to weigh in the balance the facts that was before him. And what he was saying is, based on the facts that was before him, he could not, on the balance of probability, come to the conclusion that in fact there was an error. Or that she was a victim of fraud, or that deception or coercion or anything of that nature.
Yes, thank you.
Can there be any other questions, my Lord?
You're going to come on to the deed of assent and the deed of mortgage and the attempted sale later, are you?
Yeah, but with respect to the issue, yes, my Lord. So I'm going through with respect to what? So that would have been 24. At 26, which is the Court of Appeal, again, the reasons why they are saying we should elect. They say, in addition, in arriving at the conclusion that the appellant elected to convey a beneficial interest to respondent, the judge also fell into an error. And this, we are saying, my Lord, is in fact fundamentally inaccurate based on what has already been admitted or conceded by the ancillary claimant prior to the matter being heard. They had conceded that that they were not pursuing parties who had received or were purchasers for value with respect to the property. Even the Court of Appeal agreed with that. Inherent in that statement must be an acceptance that there was in fact a conveyance of an interest by the 84 deed into the name of the present appellant.
Mr. Blaze, if I may say so, you've made that point more than once, but it puzzles me because whilst it was accepted that there was a conveyance in law, and indeed, as you pointed out, the claimant did not maintain a claim to recover the land from the people to whom it had been conveyed as bona fide purchasers for value. The essence of the case being considered, particularly in the Court of Appeal, was whether the deed should be set aside on equitable grounds by reason of mistake, in which case the fact that a conveyance did take place at law is no answer to the claim. So,
no, but sorry.
So I don't understand why you say in paragraph 26 there's some internal contradiction.
Because, my Lord, the issue of it being set aside on the grounds of mistake, that what it was decided is the law as it relates to that, my Lord, treats with the issue of whether the deed itself is void or voidable. And it was accepted that the lease was valid even if they had an opportunity to set it aside on the grounds of mistake. Then they had to have done that prior to any subsequent action. i.e. such as the bona fide purchaser for value without notice. And if they did not do that, then they would have lost the opportunity to be able to get that done. And that is the position it would have, the judge, and what he would have had to have taken into consideration at the trial itself. So, one, the issue of mistake...
I'm so sorry to interrupt you, Mr. Blaze, but again, and it's probably my fault, I'm not following that submission. Why could the deed not be set aside on equitable grounds against the defendant, even though the people to whom the defendant had sold the property might have a defence themselves in equity based on the fact that they were bona fide purchasers for value? The defendant was a mere volunteer.
No, because the ancillary defendant says that all that he was interested in were the lands that were still in the name of Selwyn Moses, and that those lands be reconveyed to them. That is what their position was, and that is what they were pursuing.
But that they weren't by that abandoning any claim in relation to the other land, even if they accepted that because of the bona fide purchasers and perhaps also because of the registration of the land, in relation to land that had been sold on, those bona fide purchasers got both the legal and the equitable title. So I can see that they were accepting that they can't pursue the reconveyance of land which has been sold on to third parties, but I don't see that they were abandoning the claim for compensation if they then set aside the deed for mistake.
No, but my lady, if they accept that there was in fact a conveyance and all of the lands were actually conveyed, if they accept that, then the issue of the deed being set aside for mistake after the intervention of a third party does not arise. Now, if, as the court would want to advance at the Court of Appeal, you would say, okay, to do equity, then the only option I may have is compensation. That's a different issue. And certainly the issue of unjust enrichment was not raised at the level of the High Court. It was raised for the first time at the level of the Court of Appeal without giving the ancillary defendant an opportunity to respond either by pleading facts or submissions to that particular cause of action.
So as I understand it, Mr. Blaze, what you're saying is if one is trying to set aside a deed in equity, there is a bar preventing you from doing that once the land has been sold to a bona fide purchase for value without notice. That stops you pulling back the title.
Correct.
What you can still do is make a personal claim. You've been referring to it as compensation. I think I'd call it restitution. For the value of the land. But that's a separate matter.
Correct, right, and I'll get to that. But what I'm saying is, it does not change the fact that the title had passed, and at the point in time that there was, when they made the concession, it could not have been an issue of now, at this time, setting it aside, because setting aside the deed accepts the fact that the deed exists. It's not an issue of, because this happened, it never existed.
But why can't the deed be set aside as against the defendant, who is a mere volunteer, whilst the persons to whom he has sold on the land have a defence in equity precisely because they are bona fide purchasers for value?
No, Malon, the first point, which is what has been dealt with, is whether there was a conveyance. The 1984 deed conveyed interest in the property to the ancillary defendant. That's the first position. And what we are saying is that is what the court was called upon to treat with, and therefore on that particular issue, the court could not have said to have fallen into error to hold that there was in fact a conveyance.
But
The second step now, sorry.
But are you saying that because the land was conveyed to bona fide purchasers, and that means that you cannot now set aside the deed, that bars not only a claim for the reconveyance of the land, but also any claim for compensation in lieu of the reconveyance of the land, because the deed has to stand? Is that what you're saying?
No, Melanie, I am taking it in steps. The issue with respect to compensation at the High Court level was based on a trust. The issue of restitution and or unjust enrichment was raised by the Court of Appeal. So what we are saying is, what was before the High Court, the court made, he can't be faulted for making a decision based on something that the Court of Appeal is now raising, which was not a cause of action before the High Court at the time that decision was made.
Can I ask you a different question, Mr. Blaze? And that is, given the errors on the deed, however we're describing that deed, I'm going to call it the deed of conveyance, but that might not be accurate. But given the errors on the face of that, is there any other interpretation other than that the transferor was making a mistake? What other interpretation could there be given those errors on the face of the document?
It could clearly have been, one of the interpretations is that because the operative clause has where the executor and beneficiary conveyed interest in the property to the defendant. So the operative clause in law effected that. If there was an error, now once that has been effected, if there's an error, then it is up to the Jude Moses, which is the ancillary claimant, at the appropriate time to make the relevant application to rectify that error. And I'm saying when you look at all of the evidence as a whole, this happened, that when you look at the evidence as a whole, we have to accept that the interest was in fact transferred.
But what I'm asking is, why didn't she use a correct document that hasn't got those errors on the face of it?
No, but there's no evidence that she was able to put forward to the court, my lord. She gave no evidence on that issue.
But it might
that was what the court was saying. There's a defect. She gave no evidence.
But it might be said that it's then obvious that she was making an important mistake, because she's used the word beneficiary, whereas I think on your analysis, she was just making a deed of gift, which she could have done on a form that had no errors in it at all.
No, but my lord, what pursuant to the Conveyancing and Law Property Act, the operative clause operated to convey all the interests to the ancillary defendant. If they want to put forward the issue of, so that happened, the only way that could now change is if you actively try to reverse it. But you can't say that even if an interpretation of it was that it was an error, that the conveyance did not take place.
May I ask the question perhaps a slightly different way? Do you accept that the deed of the 12th of October 1984 does indicate her belief that the lands were amounted to property that he was entitled to under the will.
The first recital says that, correct.
And do you accept that only 1 year later she executed a deed where she sought to convey these lands to herself as the sole beneficiary under the will of those lands?
That was in 1985 deed, but that is not how you set aside the first conveyance.
Well, leave aside the question of setting aside for a moment. Just put that to one side. The question I'm putting to you is whether or not those two documents together do give rise to a reasonable inference, at the least, that she made a mistake in executing the 12th of October 1984 deed. I appreciate setting it aside is a different matter. At the moment, I'm purely looking at the question of whether or not she made a mistake.
Right. So, my lord, what I'm saying is, from the standpoint of the trial judge took into consideration the 1984 deed as well as the 1985 deed. So, for him to fall into error, he had to, and he's saying, I need more.
Well, let me put to you the other two documents upon which the Court of Appeal relied and to which they attached weight, namely the deed of mortgage of the 3rd of August 1993 and the deed of release of the 22nd of April 1994.
But as one of that will be relevant, which is the deed of mortgage. The release is what the bank will do once there's a payoff. So what is relevant will be the deed of mortgage. Right, my lord? And that also was taken into consideration by the court as well. Again, my lord, if the 1985 deed fails, then everything else fails. But if we are looking at, based on what was before the court, which was there a transfer? And 2, was there a trust established?
Well, I'm looking at a slightly different question at the moment, namely whether or not the judge at trial took into account all of these documents in relation to the question of whether or not she made a mistake.
My lord, he did take into consideration all of those documents. But the relevant issue he had to decide is whether there was a transfer of the interest from party 1 to party 2, and whether there was the creation of any trust. That is what was before the court to decide. And also there is the issue of fraud. So his decisions would have been made based on the case that had to be answered. If the case had arisen, if they had raised the case of unjust restitution or even the issue of unjust enrichment, then, which is the form of restitution, then the courts will have had to now consider that aspect. But that is not what was before the court at the High Court level, my lord.
I don't understand, Mr. Blaze, where your trust is coming from. Why are you using the terminology of trust? I thought
because, my lord, that was the cause of action at the High Court level.
But it was a trust based on mistake, presumably.
No, my lord. Both the High Court and the Court of Appeal ruled that no evidence was put forward in support of any trust.
But what trust was said to have come into existence?
The trust they are saying is, he having sold the land, whatever money he received would have been held on trust.
Well, that could only be because he had held the land on trust.
Well, exactly, my lady.
And then it
But you were
converts
unable
to a
to
trust
establish
over the
the existence
proceeds.
of any trust.
But that I don't recall that a trust argument was raised beyond that being the way of describing the remedy that arises if you set aside the deed because of mistake.
No, my lady. The trust was raised from the standpoint of if the land is properly in the name of the defendant and he did in fact sell it, then whatever money he received will be deemed to be held on trust for the benefit of Jude Moses, with, like I said, both the High Court and the Court of Appeal indicated that he had not advanced.
Why would he hold those proceeds on trust for her? Why would he hold them on trust for her? Why was it said that they were held on trust?
They did not plead why, my lady, which is why they failed on that particular point.
But it seems to me that the issue that you need to confront is whether or not she was mistaken when she made the deed of the 12th of October.
Well, that particular point, my lord, I think is relevant to the second submission that deals with the issue of unjust enrichment. But the first point that deals with the issue of whether the judge, based on what was before him initially, made a fundamental error. We are saying that the judge did not make a fundamental error. The judge took into consideration everything that the Court of Appeal took into consideration. Plus, he had additional information by virtue of the conduct of the trial itself, and he came to a particular conclusion. So we are saying that the judge was not fundamentally wrong.
Mr. Blaze, I wonder whether it might be said that when you say the judge took certain matters into consideration, all that you're pointing to is that the judge referred to particular matters. But as I understand the criticism made by the Court of Appeal of his judgment, there isn't a standing back by him to weigh up factors on the one side and on the other side in relation to the question whether a mistake occurred. So it may not be sufficient for your submission simply to say that the judge happened to mention particular points if they didn't feed into some sort of weighing exercise on the relevant question he had to decide.
Yeah, but what we are saying is that the relevant question he had to decide was whether the 1984 deed effectively transferred the interest to the ancillary defendant. That was what he had to decide.
No, it wasn't.
No.
The question he had to decide was whether there was a mistake. That's the question the first instance judge was deciding. Was she mistaken in making that transfer, that conveyance?
No, but it was established that even if it was a mistake, that did not prevent the transfer. The issue of mistake deals with the issue of the remedy.
Well,
but the transfer itself, it did not affect that. Even if it was a mistake, it did not affect that fact that title passed.
We understand that submission, but
Right.
we would be grateful for your assistance on the first aspect of it, namely whether or not the judge ever properly evaluated all of these factors in considering whether there was a mistake at all. You may say he didn't, but he didn't need to. That may be your answer. But insofar as you're saying that he actually went further and did weigh them up and decided there wasn't a mistake at all, we'd be grateful for you to if you would show us the passage in the judgment where he does that.
No, my lord, but if you look at paragraph 30, what page? At 127.
Yeah.
All right, my lord, the court specifically, he looked at the deed. He acknowledged that there were errors in the deed. And he said there was no evidence adduced before the court that could have led the court to conclude that in 1984 was executed as a result of mistake of fact, or that the ancillary claimant was the victim of fraud, deception, undue influence, or coercion. So the court did consider the issue of mistake. When we go down to paragraph 37.
But the criticism made by the Court of Appeal, I appreciate I'm repeating a point I've already put to you, Mr. Blaise, is that the judge does not seem to appreciate that the very fact that the mistake is made in the 1984 deed is potentially evidence indicating that the claimant was indeed mistaken when she executed that deed. He refers to there being an error, but then he says there's no evidence adduced to the court that could have led the court to conclude that a mistake was made. And it was that very tension that the Court of Appeal at paragraph 25 considered indicated that he had indeed gone wrong in his approach.
No, but my lord, what he said, no evidence, he's meaning above what is in the deed, because he mentions what is in the deed. He mentions the particular clause. And then he says there was no evidence, and it obviously means above what was in the deed itself, in support that it was done via mistake. So in the High Court's decision, it acknowledged. So we can't say that he did not acknowledge that that was before him. He acknowledged it, but he's saying there is no evidence above that confirms or corroborates that it was in fact a mistake. Even the Court of Appeal indicated that based on these facts, it could have been either two scenarios. One, she did the deed initially and changed her mind. All right, and then two was the second one. They acknowledged that exists, but there was no evidence, and this is a case that was brought by the claimant. So therefore, the burden of proof was on them.
And Mr. Blaise, can I ask, why does the judge appear to have left out, even if one construes paragraph 35 as you invite us to do, the other documents that Lord Kitchen referred you to? Because might it not be said that those additional documents and features of the case is evidence over and above what was on the face of the 1984 deed, capable of indicating that a mistake had been made?
My lord, at paragraph 37, he referred to those documents, my lord. He said, in the case the ancillary claimant wore two hats, one as representative and that. The court also considered the effect of the 85 deed by virtue of this deed. The ancillary claimant, after executing the 84 deed, assented. This 85 was done in the absence of the 84 deed being declared null and void. At the time the 85 deed was executed, the Darwin lands could not have been transferred by her, as the said lands were no longer vested in the estate, nor did she have any authority over same.
So, if I may say so, that seems to be addressing the question of the claimant's authority to deal with the property, rather than looking at this material in relation to the question the judge had to determine whether she had previously made a mistake in the 1984 deed.
No, but my lord, what we are saying is, if I may, based on what was before the court, and I say this again, the issue of mistake will treat with the issue of, if it was before the court, unjust enrichment or restitution, both of which were not before the court. The court had to treat with the issue what was before it, which is the issue of the trust, and it being set aside at this stage based on the issue that was before of the mistake that was before the court, and also based on the concession made by the claimant. Because if the ancillary claimant is saying we are not going after anyone who has purchased the land for value without notice, then inherent is that is an acceptance that there was in fact a transfer.
But
The issue of the
I think, Mr. Blaze, if I may say so, certainly from my perspective, there's no doubt that in the analysis of the Court of Appeal, there was a transfer. There was a transfer, a conveyance at law that took effect at law. But that's not an answer to the case that was being considered by the Court of Appeal, whether that conveyance should be set aside in equity, and then as against whom.
Well, right, my lord, but what I'm saying is, that is what the Court of Appeal, from the standpoint of introducing, because if we take out unjust enrichment, then the appeal to the Court of Appeal fails. On the only basis that the Court of Appeal allowed the appeal is because the Court of Appeal introduced the new cause of action of unjust enrichment. But if we take that out, my lord, the appeal failed. So it's only in light and within the context of treating with the issue of unjust enrichment that the Court of Appeal said we need to deal with the issue of mistake. But that was not before the court below.
I just don't think that's right, Mr. Blaze. The issue of mistake is not solely tied to an unjust enrichment claim. The mistake is the reason why one may be able to set aside a legally valid deed in equity.
Even without that affecting the equitable and legal title of subsequent bona fide purchasers.
In fact,
No,
I'm sorry to add to the points that have just been made, but if I could put my point on the table, because it runs with what my colleagues have just said. Wasn't it, in fact, the other way round from what you're saying, i.e., mistake only comes in because unjust enrichment is raised in the Court of Appeal? Mistake was always at the forefront of the claimant's case. And the issue then, which the Court of Appeal latched onto, was what consequence should follow if the deed was set aside in equity. And it was that which, looking at the transcript of the hearing in the Court of Appeal, led them to raise directly with you the question of unjust enrichment, and you did indeed make submissions to them on the question of unjust enrichment.
No, my lord, I did not make submissions. What they asked was, if they pursued unjust enrichment, what would be the appropriate award? The issue of unjust enrichment, whether it existed, and everything else that would have followed, there was no invitation to make any submissions on that. They asked if that, and I said, well, if that was the case, then the only measure would be what the lands were sold for initially.
Mr. Blaze, I'm very sorry to pick you up on that, but the Court of Appeal most definitely did give you the opportunity to make submissions about the extent of unjust enrichment, and indeed you did so, saying that it should be capped at $300,000.
Right, but my lord, if we may, and I will go back to that position, where's the notes of evidence. All right, because I remember clearly, my lord, when the court said, if the court is to pursue or to say about unjust enrichment, they just asked me specifically about what it should be. And when I get to deal with the issue of unjust enrichment, my lord, I will treat more in depth on that point.
Just so that you know, Mr. Blaze, that the particular passage I had in mind is, and I'm afraid I'll have to give you the internal page numbering of the transcript. It's pages 35 to 36 of the transcript of the hearing in the Court of Appeal, which is something like 602 in the key documents bundle, and I'm afraid I just don't have it.
92 to 93 of the key document.
you have the passage I'm referring to,
of the
Mr.
key
Blaze?
document.
It's
Right,
at the
so
foot of internal page 35. Justice of Appeal Jones says, "Now let me ask you this," and this is, I'll tell you, this is the crux of what's bothering me. And then she asks you directly about unjust enrichment, if there is a finding that the deed can be set aside for mistake.
It's page 590 of the...
I'm very grateful to Lady Rose.
93 of the key bundle.
No, 590 of the electronic bundle.
Yes. And yes, page 590, it seems, of the key bundle, but I don't trust those page numbers because they're...
Right. So, my lord, all I was asked is the issue of quantification.
Yeah. Well, the High Court didn't have to deal with quantification because, or how to fashion the remedy, because they held there was no mistake. But once...
No, well, it was not pleaded, my lady.
Right.
Justice enrichment was not pleaded
if
in the High
Court
Court.
of Appeal are going to find there was a mistake and to set aside, then they do have to grapple with the issue that was not grappled with by the High Court as to
Correct, my
what should
lady.
the remedy
So,
be. Yeah.
right, correct. And I'm saying that that was not an issue that the High Court grappled with.
No.
And when the issue was raised by Justice Appeal Jones, it was raised solely on the issue of quantum. So, and that was the first time we had to deal with that. No submission, nothing was not given the opportunity to respond or put in any information with respect to the whole issue of unjust enrichment in the first place.
But the hearing was both in relation to liability and remedy, wasn't it? So presumably you must have realised that if the Court of Appeal was against you and held that there was a mistake and the deed should be set aside, they would want to know what remedy to grant.
But, my lord, when you look at the grounds of appeal dealt with the issue of trust, because that is what they pleaded at the High Court. And the Court of Appeal themselves said, no, we can't support you on an issue of trust. So that is what we prepared to deal with.
But
Issue that were raised
Mr. Blaze, might it not be said, looking at this same passage in the transcript in the Court of Appeal, that Justice of Appeal Jones sets out very clearly the basis of her question to you? She appreciates that she's asking you to make some assumptions against the submissions that you were making to her. She says, let's assume the deed contained a mistake of fact, and let's assume that in those circumstances, Mrs. Moses could apply to set aside the deed, and that's what she has done in this case, because it contained a mistake of fact. So the Court of Appeal has put to you very distinctly the basis for their questions then on unjust enrichment. You say it's just a question of quantification, but it's a matter of quantification of remedy on very precise preconditions that the court has spelled out for you, isn't it?
No, and the judge spelled out the precondition that assuming it exists, how you quantify. I was not invited to make any submission on whether it existed or not.
That I don't understand. This is Justice Jones inviting you to make submissions. Why do you say you were not
quantum,
invited to make submissions?
on quantum, on the issue of quantum only.
But isn't she saying, if we're against you on the question of mistake, what are your submissions on what we should then do, or what we can then do? Which is a standard question for any appellate court to ask, or any first instance judge. What's the next step if I'm against you?
No, my lord, that's not what the court indicated as it's seen there. The court said, if we assume unjust enrichment, how do we quantify? That was it. No aspect of it dealt with the issue of submissions, even at that stage, which we would have had to prepare and submit in any event. On the issue of unjust enrichment, it was a matter raised by the Court of Appeal for the first time. While we were on our legs. And it wasn't to invite submission on that. It was, if we assume this exists and assume this of this, how do we quantify? And then she said the quantification should be based on what it's sold now or later. That is what the discussion was about.
Mr. Blaze, can I ask you a different question? You started to tell us about the two scenarios that the Court of Appeal referred to. I think this is at paragraph 34 of the Court of Appeal decision. That is, she either intended to transfer the land and changed her mind, or she was mistaken.
Right, so my lord, and that was...
My question is, why doesn't the terminology of the 12th of October deed point to the second of those being the correct scenario? Why, if somebody was intending to make the transfer and then just changed her mind, why would she use incorrect documentation?
It may have made it because there would have been an error, my lord. That's one, there would have been an error in the drafting of it. So for instance, if the word beneficiary, if that one word beneficiary is changed and put the executor or the legal personal representative, that one word is changed, then the entire document changes.
But it wasn't.
No, but I understand. But what I'm saying, my lord, it was an error. So then necessarily say that error was so detrimental and of such a magnitude as to lead to only one conclusion. Respectfully, my lord, be saying that it does not.
When you say it was an error, do you mean an error to use that documentation?
I am saying it was, the possibility was that it was an error. So instead of having the word beneficiary, it could have had the word the personal representative. Just that one word, my lord, changes the entire document.
Well, it's a bit more than that, isn't it? Because the whole preamble is directed to the subject matter of the deed being the land which the deceased intended to bequeath and devise to the beneficiary. The beneficiary, the beneficiary being the person to whom the property, the subject of the deed, is going to be conveyed. But we know perfectly well, and it's not disputed, that the particular property that we're interested in was never going to be bequeathed to this particular beneficiary.
Right, that is why the deed itself conveyed. So if I am the owner of both the legal and the equitable interest, then I can transfer it to whoever I wish.
But why use incorrect documentation? What explains that? Why use the word beneficiary if you are simply talking about a straightforward gift?
Yes, but my lord, the court below never said it does not have that other possibility or not. The court below never said that. What the court below said is that there is insufficient information above just looking at the content of the deed which they refer to suggest to prove on a balance of probability that she did not intend to convey the property to him. There's just insufficient evidence.
Well,
I think one of the criticisms, at least by the Court of Appeal, was that the trial judge didn't stand back and make an assessment of the very points that Lord Burrows is putting to you now. We don't look and find in the trial judge's judgment an assessment, well, yes, on the one hand, use of the word beneficiary, use of the word bequeath, as Lord Kitchen points out, are all indicative of the claimant thinking that she's doing something to implement the wishes of the testator. which we know, in fact, were not the wishes of the testator. We don't find anything like that by way of assessment by the trial judge to put into the balance in determining whether, on the balance of probabilities, a mistake was or was not made, do we?
Malone, I wasn't clear exactly what you were asking me.
So, my Lord Burrows asked you, why would the claimant have used the wrong documentation, where if she was making a gift, she could easily have used proper documentation? And as I noted your answer, you said the court below didn't say that. And what I was putting to you is, indeed, the court didn't say that. It didn't seem to make any assessment of the point that Lord Burrows was putting to you. And the Court of Appeal regarded that as indicative of the first instance judge erring in principle, because he had not addressed the full panoply of the evidence that bore on the question that he had to decide, namely whether the claimant made a mistake in relation to the conveyance.
No, but Malone, I respectfully disagree. What he had to decide at that point, because the mistake goes into the remedy, what he had to decide at that point was whether there was a proper conveyance of the land from the claimant from the ancillary claimant to the ancillary defendant. He also had to decide whether there was any trust created by virtue of that. That is what was before the court below. The issue of mistake would go towards another cause of action which was not before the court, which is the restitution and unjust enrichment. That was not before the court.
Yeah. And then it may be said, if you go on to page 413, Julie Moses is looking at the other side of the coin, namely, she's now conveying to herself the residue, which she understood that she was the beneficiary of under the will.
But Lord, and it has been accepted that that was null and void, because if you have already divested yourself without setting aside the 84 deed.
Well, of course, I understand that, but there's no consideration by the judge of these two documents together.
Look, there is, my Lord, if you look at the paragraph 37, at paragraph 37, he looks at both the 84 and the 85 deed.
Indeed, but not from the perspective of whether or not there was a mistake. The judge is looking at it from the perspective of whether or not it was effective. But I understand your submission. There is an assessment of it there, but I'm putting to you that it's not an assessment in relation to whether or not she made a mistake.
Well, all I've been saying, my Lord, if I repeat again, and I apologize for repeating.
Your answer is that mistake wasn't an issue before the judge at first instance.
From the standpoint, it was not from the standpoint of the remedy that they were seeking at the judge at first instance.
Yeah.
It was the issue of a trust, is what they were, the case that they were advancing.
Yeah.
Initially was trust and fraud, and at the trial itself, they abandoned the fraud to pursue trust. Even on the appeal, they were trying to advance the issue of a trust. So all of the grounds of appeal that they filed, they did not succeed. And then the Court of Appeal itself introduced the issue of unjust enrichment on the date of the hearing.
No, I think that's...
Could you help us with the next question, which is let's assume for a moment, I'm not deciding at all, but assume for a moment that we're against you up till now. We then get to the question of remedy, and here the Court of Appeal went on to consider the position in the light of the fact that the land was no longer in the hands of the respondent before the Court of Appeal. And the the Court of Appeal awarded the total sum of $620,000. What do you say about that figure, and whether or not it was the appropriate figure to award, or whether or not $300,000 was the appropriate figure to award?
Right. So your position is this, my lord. So if the court is not with me on that particular point, then I move on to the issue of that the court raised with respect to unjust enrichment. And in that regard, my lord, I would want to refer the court to my submissions at what page is it? At page 29 of the key bundle, my lord.
Yeah.
My lady. So what the Court of Appeal did is said, you know what? The court didn't do that, made an error. We can now raise the issue of unjust enrichment. And our point is that the court in doing that has to look at, because we've not been given an opportunity to put any additional evidence, and additionally we were not given an opportunity to submit as well. But the court had to be guided by the law with respect to considering the issue of unjust enrichment. And in that regard, my lord, I refer the court to the Privy Council decision in Samsundar versus Appellant Insurance Company. And that is on page 29 of my written submissions. And in which they say it has now become conventional to recognize that a claim in the law of unjust enrichment has three central elements, which the claimant must prove: that the defendant has been enriched, that the enrichment was at the claimant's expense, and that the enrichment at the claimant's expense was unjust. If those three elements are established by the claimant, it is then for the defendant to prove that there is a defense. I also refer to the case of Kleinsworth and Benson, which is at the following page, my lord, which is 30, in which it was said that subject to any defenses that may arise from these circumstances, a claim for restitution of money paid under a mistake raises three questions. Was there a mistake? Did the mistake cause the payment? And did the payee have a right to receive the sum which was paid to him? The first question arises because the mistake provides the cause of action for recovery of the money had and received by the payee. Unless the payee can prove that he acted under a mistake, he cannot maintain an action for money had and received. Prove on this ground. The second question arises because it will not be enough for the payer to prove that he made a mistake. He must prove that he would not have made the payment had he known of his mistake at the time when it was made. Now go on to the next question. The third question arises where the payee cannot be said to have been unjustly enriched if he was entitled to receive the sum paid to him. I also refer the court to the Learning and Civil Appeal number P66 of 2015, Anuri Mahabir versus Alim Mohammed, which deals with the issue of the delay. Now, delay, the doctrine of laches usually applies where it would be unjust or inequitable to grant relief, for example, where the delay is accompanied by some change of circumstances. Where there has been acquiescence on the part of the claimant and the defendant has changed his position in reliance on it. Where the claimant's conduct might fairly be regarded as equivalent to a waiver, or where by his conduct he has put the defendant in a position where it would be unreasonable to place him until later claim the equitable remedy.
Mr. Blaze, I'm a little bit puzzled why you're addressing us on delay. As I understand it, delay was not an issue before the Court of Appeal. There was no respondent's notice from you saying that if the appeal succeeded on grounds of the mistake that was being alleged, that nonetheless relief should be refused because of delay.
No,
so that simply was not an issue before the Court of Appeal, as I understand it.
No, but my Lord, the Court of Appeal, of its own motion, is looking at unjust enrichment. And our submission is, we were not invited to make submissions on that, but our submission is, if the court was doing that, they can't cherry pick. They have to look at all of the facts affecting the issue of unjust enrichment. So all of that fact would have been privy to them, because they are now independent of the pleadings by the claimant and independent of any response or anything by the defendant. They are now saying we are going to look into unjust enrichment. And if the Court of Appeal is doing that, they have to look at all the aspects of unjust enrichment, my Lord. Especially from the standpoint of it being...
Again, forgive me for expressing my puzzlement. Delay isn't a defence to unjust enrichment. Delay or laches may be a defence to equitable relief, including the relief of setting aside in equity the deed. But that wasn't a matter that was live before the Court of Appeal.
No, well, my Lord, in Samsudir, the Privy Council decision in Samsudir does not suggest that. In Samsudir, which dealt with unjust enrichment, they said the important point for the case is that the Court of Appeal did not, and this is on page 20, the Court of Appeal did not deal with change of position, and that not to do so while concluding that the claimant shall succeed on the basis of unjust enrichment was an error of principle. The planning concluded that on the unjust enrichment issue, the Court of Appeal was incorrect to decide that a claim in unjust enrichment should succeed on the basis of legal compulsion and mistake of law. And mistake of law was neither pleaded nor proved. Issues relating to the defendant's enrichment and defenses provide further reasons why the unjust enrichment claim based on legal compulsion should not have been upheld, and while it is now too late to raise a claim based on mistake. But in that particular, in Samsudir, it says otherwise, my Lord. It says when the court is looking at unjust enrichment, it has to look at everything. And especially in circumstances where it was not pleaded or proved at the High Court. And they say for them not to do that is a fundamental error of principle.
Well, may I put it to you? I mean, what could have been said in relation to the $300,000? The land was no longer in the hands of the respondent at that stage before the Court of Appeal. It had been sold on for $300,000. The evidence was that then further development was carried out. But in relation to that first $300,000 that was received in relation to this land from its sale, what can be the answer to that in terms of the claim for compensations restitution?
With respect to at the time, again, my Lord, the ancillary claimant would have been aware. Excuse me, my Lord?
Yes, we can hear you. We can hear you.
All right, okay, yes. The ancillary claim, the ancillary claimant would have been aware, and she made no moves with respect to the issue of curing what she knew or what she believed to be a mistake. So, my Lord, the question is whether she has accepted and adopted it. The evidence is that she tried to sell. It was determined conclusively that the land was in the name of Selwyn Moses. And then she did nothing with respect to the issue of making any claims. Now, what happened in 2000, and that is from 2000 to 2009. What happened in 2009 now is an issue arose where the daughter of Jude Moses, with the use of a power of attorney, then with the use of the power of attorney, and without any, and the evidence is in there, without any instructions from the mother, then decided to raise an issue. And that is a delay of, in the very least, 8 years. At least 30 years, I believe, or 20 years after the initial deal, and 30 years after she was confronted by the ancillary defendant. I said, hey, this land is mine. So the question is, has she therefore adopted it? And she's entitled to do that. She's entitled to do that. And there's no evidence that suggests that she didn't adopt the position and said, you know what, it's my son, no problem, and I leave it at that. Because the evidence is clear on the issue that the actual process and the movement of this matter was pursuant to the sister by a power of attorney obtained in 2006 when the mother had a stroke and could not deal with her matter directly. So your position is that delay and the fact that she personally did not treat with it cannot be viewed as a position that the defendant adopted when, from the point in time that she knew, and 8 years thereafter, she did nothing about it.
Mr. Blaze, on unjust enrichment, can I just check that if all your other submissions failed, you would nonetheless maintain the position that you maintained in the Court of Appeal, that if unjust enrichment is available as a remedy, it ought to be limited to the $300,000, which was the initial transaction price received by the defendant, and should not extend to the $620,000. I just want to check that that remains your position.
Yes, my Lord. And there's evidence there's evidence that the mother, at the point in time, wanted to sell the land for $300,000. That is what was her intent at that point in time. Anything outside of that, my Lord, if there's anything, would be unfair from the standpoint of now they are gaining a benefit, for which, after sitting back, and the cases are clear on that, after sitting back 30 years, and if I refer to the case of Ramdeen versus Dyson, which I have at page 31, it says, if a stranger begins to build on land, supposing it to be his own, and I, perceiving his mistake, abstain from setting him right and leave him to persevere in his error, a court of equity will not allow me afterwards to assert my title to the land on which he had expended money on the supposition the land was his own. It considered that when I saw the mistake into which he had fallen, it was my duty to be active, and to state my adverse title, and that it would be dishonest in me to remain willfully passive on such an occasion in order afterwards to profit by the mistake which I might have prevented. So,
did you say that did you say that she wanted to sell the land for $300,000?
Yes, my Lord. And then she would have found out with respect to the issue of the land not being in her name. And then did nothing.
Is this what you're referring to in paragraph 11 of your background, that it was the respondent who put the land up for sale in 1999 to 2000 with an advertisement?
No, Mother, this is in the witness statements given in evidence. If you go on the notes of evidence of Selwyn Moses, he gives evidence. Could you pull it for me, please? 218. If we look at page 218 of the key documents bundle.
218.
And the notes of evidence.
Yes.
It says, because how did you come about to know that the existence of the 84 deed? Because they were selling the land at 300. Who was selling the land? My mother. She said 300 she wanted for the land. So that is evidence that has not been disputed with respect to quantum of what was being requested at that point in time.
So after the deeds that we're concerned with here, the 1984 and the 1985 deed, the mother, Jude, expressed an interest in selling the land for $300,000.
Correct.
That's to say Jude.
That is Jude, the mother.
Yeah.
That's page 387 of the bundle.
Yeah. And she considered that she was entitled to sell the land at that stage and wanted to secure $300,000 for it.
Excuse me, Mother?
She understood that she was entitled to sell the land at that time, and she thought it was worth $300,000. That was what she hoped to get for it if it was sold.
That is at that point in time.
And at this point in time, Selwyn didn't know, I think, about the 1984 deed.
That is, at that point in time is when he found out about the 1984 deed.
Right, so that's why he doesn't go to her and say, well, why are you purporting to sell this? You've given it to me, because he doesn't know that that deed existed. Is that right?
That is correct, my lord. Milady, sorry. That is correct with respect to on that particular point.
Yeah.
But we had also made submissions with respect to his occupation of the lands, and we are saying that even if the court is to consider afresh matters before the court below, they also had an obligation to consider the issue of adverse possession and possessory title. Now, the court below made a finding of fact that the ancillary defendant was let into occupation of the land by the permission of his father and remained in occupation of the land after his father died until for the whole duration of the period. The court, however, made a statement that because he entered with permission, he could not be in adverse occupation. And we are saying that that permission is in fact incorrect. While the father was alive, he would be there with the father's permission, or with a license if you wish. But as soon as the father died, that license would have died, and he therefore would have been in adverse possession from 1982, which is when the father died, to the present time. So that's why we had advanced the point. Based on the finding of the court, I think Stephen accept a garage with some company thing was stored. The claimant was in fact in occupation of that land exclusively to the exclusion of everyone else, because the court said they did not, as a finding of fact, accept the evidence of the ancillary claimant witnesses, but accepted as truthful the evidence of the ancillary defendant and his witnesses, and made a finding which the appeal court did not interfere with, that he was in occupation of that land from 1982 up to the present time. 16 years from 1982 would put 1998, which would mean that by 1998, if there's anyone else who had a title or claim to the land, then that person's interest would have been extinguished. And that's pursuant to the Real Property Limitation Act.
Yeah.
The Real Property Limitation Act also establishes that even if you enter with permission, it does not mean that once there has been a termination, that forever you can't be in adverse possession. All right, so once the license, the father died, license was extinguished, he's in adverse possession from there. And the court was obligated to look at that as well if they are looking at the evidence and the situation anew.
Yeah. Now, I'm conscious that we've asked you a lot of questions, and it's 4:15 our time in the afternoon. You have another 15 minutes according to the schedule. Are there particular submissions that you'd like to make to us over the next few minutes that we haven't covered already?
Well, Malone, I have put forward the first submission with respect to the judge following the error. I put in the submission with respect to, if taken into account unjust enrichment, then you need to look at the entire, especially been raised for the first time. And I also indicated that if the judge is looking at everything afresh, you're obligated to also look at the claim that we made with respect to adverse possession and possessory title. I also indicated as well that the finding of the court in the High Court, which is that the 84 deed did operate to convey the property to the defendant, to the ancillary defendant, is not a finding that the Court of Appeal could have set aside, because that's a position that all parties accepted. The issue really would have been in treating with mistake and whatever remedy could flow from that, if any, which is what the Court of Appeal was dealing with as a new issue on the issue of unjust enrichment. So, Malone, unless I could be of any further assistance, those are my submissions relative to this particular matter.
I wasn't intending to cut you short. If there's anything more you want to say that we haven't covered, then now's your opportunity. But I think you're comfortable that you've covered the ground.
So if I may, I would certainly want to, on the issue of of delay, and the evidence in support of it, I would want to make reference to the witness statement of Selwyn Moses, which is 212 of the full electronic bundle.
Yes.
All right, at paragraph 17, where it says Jude Moses has never been in occupation of the land. She has always been aware of the activities taking place with respect to the development of the land and its occupation by me, and has never taken any steps to challenge my ownership or possession of the land or any portion of it, at least prior to this proceeding, which was actually initiated by the sister under power of attorney.
Yeah.
And that has not been challenged at all, my lords and my ladies. And if you look at the page 63 of the Respondent, the full electronic bundle, and we look at the witness statement of Flora page 63 of the full electronic bundle. We look at the witness statement of Flora Moses, my lord, paragraph 19.
Yes.
Again, she again affirms that in 1999 to 2000, they became aware of it, and nothing was done with respect to the issue of the correction of that, of the mistake. So she confirms the duration of time for which there was been delay, for which the rules are saying that must be taken into consideration to make a determination as to whether they're entitled to a claim with respect to the issue of unjust enrichment.
Yeah.
What else? No.
Anything else?
All right. No, my lord, I believe that is the submissions and the facts and authorities that we depend on with respect to the claim.
Well, Mr. Blaze, thank you very much. The board is most grateful to you and those assisting you for your submissions. We will adjourn now. That concludes this hearing, and we will consider everything that you've said to us together with the written submissions and the judgments below with great care, and we will issue our decision as soon as we can.
Thank you very much to the board.
Thank you very much.
For accommodating me. Thank you very much.
Thank you.
May I take my leave, sir?